towards the contract where arbitration clause is inserted, and therefore here a lot of examination can be started. How we deal with this method of arbitrability, which is the law on which we get into this examination, which no matter the procedural law, it's just substantial. So I think you will really want to give us some insights. Thank you so much.
Thank you, Professor. I want to take a moment to thank the initiators of this conference, Dean Bias and Professor Lewa and Professor Christina Stoika for her support. Yes, the subject of my dissertation thesis and the subject of the discussion is actually quite vast. I was surprised myself when I started to get a little bit deeper into the research. The motto has a little bit to do with arbitration in general, even if it's not a new procedure, as the DN said. It has certainly opened some horizons that litigation has not seen before. Okay, so we'll start by stating that arbitration is indeed, commercial arbitration is indeed nowadays the preferred method of settling disputes. And these are the advantages of arbitration that we'll go really fast through: the speed of the procedure, flexibility, the possibility of choosing their own arbitrators. And we get to the main feature and function of arbitration, which is to finally settle disputes outside of the rule of law and with the words that are enforceable worldwide. So basically, without the possibility to have a binding solution, arbitration would be pointless, if you can say so. And we get to the question whether the party consent is indeed sufficient to ensure the efficacy of arbitration. Here is where we get to the main challenge that is faced by arbitration, and it is the fact that it is tightly contingent to the legitimacy that is granted to it by a higher force, to say so, which is the state, the law, basically. So arbitration faces a double bond. First of all, it's the party's will, because it's the point from which it derives its existence. Arbitration is essentially a mechanism for dispute resolution of financial nature. And the bigger limit, to say so, is the established legal provisions within which it has to remain in order to be recognized, in order to be legal, and in order to have an enforceable finality. All this introduction has a reason, because I believe arbitrability is basically the point of collision of this contractual nature of arbitration on the one hand, and public authority necessity to abide the law on the other hand. We have three cornerstones, pillars of arbitration that ensure the efficacy of this mechanism. We need a valid arbitration agreement, which includes the condition of capacity of the signatory parties. We need subject matter that is capable of settlement by arbitration, which what is exactly arbitrability, and also we need the observance of public rules. Okay. So what is arbitrability? We don't have no national laws or international convention that will define it. We have the New York Convention, which sets it as a condition for recognition and enforcement of arbitral awards. We also have Article 34-36 in the Constitutional Model Law that sets the same requirement. And we have the scholarly writing, which have been tasked to define the term. There are a lot of definitions given. Perhaps the most relevant one, my favorite, is that arbitrability is basically the essential dividing line between public and private justice. Okay, we have two categories of arbitrability: objective arbitrability or arbitrability materie, which is actually answering the question, what are the disputes that can legally be referred to arbitration? And we have subjective arbitrability, answers the question who can submit to arbitration and dispute to which it is a party based on an otherwise valid arbitration agreement. We'll briefly analyze objective arbitrability and then we'll get to subjective arbitrability. And what actually raised my curiosity when I started studying in order to draft my paper is that there are quite a lot of misconceptions that gravitate over the area, and namely that arbitrability is very often confused with either public policy limitations or the validity of the arbitration agreement. And here we get to the separability principle. Arbitrability is none of the above. I believe that arbitrability is a question of jurisdiction. It is a prerequisite for the arbitral tribunal to be legal vested. And this is the reason why. Perhaps the most relevant argument is that even the New York Convention on International Arbitration is itself sets public policy and inarbitrability as two separate, distinct grounds for refusal of recognition or enforcement of the award. And also the fact that, or mainly, first of all, the fact that a dispute involves matters of mandatory law or public policy does not necessarily mean that the said dispute is non-arbitrary. Over the years, there are a lot of, I don't know how to say that, it was believed that arbitrators should not have the power to decide upon disputes that involve public policy questions, or that maybe they are unfit to apply, for example, the principle rules regarding due process, which is not true. Presently, it was recognized multiple times that arbitrators are entitled to. So basically, the distinction between public policy doctrine and the non-arbitrability doctrine is that arbitral awards are not enforceable and not recognized on public policy grounds because the results reached by the said awards are in contradiction with the mandatory law. While when we're dealing with arbitrability, basically the results are not so much relevant because the matter itself cannot be submitted to arbitration, but there cannot be a binding decision. Excuse me, take a sip. Okay, so in conclusion, arbitrability is just a matter of jurisdiction. It has nothing to do with public policy, or it has very little to do. So sometimes they overlap indeed, and it has also nothing to do with the validity or the legality of the arbitration agreement. This is confirmed by the New York Convention itself and many national laws that regulate the validity of the arbitration agreement and the arbitrability of subject matters in different provisions. And also, here are the things that basically make the distinction. Different kind of rules are applicable in order to decide on the validity of the arbitration agreement and on the arbitrability on the other hand. And also, the validity of the arbitration agreement is an aspect that is analyzed with respect to the time of the conclusion of the arbitration agreement, while arbitrability is very difficult to determine with certainty at the time of the conclusion. Okay, so regarding the international review of objective arbitrability, basically all national laws recognize that any dispute of pecuniary or patrimonial nature regarding rights that are generally transferable can be arbitrated upon. We have the recognition of the fact that every state has the freedom to set its own limits, but we also have the minimal limits of the New York Convention that have Nowadays, it is recognized that even disputes regarding intellectual property matters, competition, antitrust, securities law, and even claims sounding intellectual liability are arbitrable. Okay. Some of the matters that are generally non-arbitrable are bankruptcy matters, employment agreements, consumer transactions, matters of personal status, of course, rights that are generally non-transferable. With regard to the national review, we have the municipal procedure code provisions that are a little bit different from the previous provisions, and they eliminated the requirement for a dispute being of a pecuniary nature, and instead provided expressly the matters which are not arbitrable, which is personal status, personal capacity, characteristic relations, and the ransom of which parties cannot fully disclose. In international arbitration, we also have the same conditions. And very quickly to subjective inarbitrability, it's the same distinction that has to be made as for the objective arbitrability. It has nothing to do with the capacity of the party. It's more a problem of quality of the party to an already valid arbitration agreement, to an arbitration agreement that is concluded by persons who have the capacity to conclude a contract. And we have in international arbitration the application of the principle that no one may set himself in contradiction to his own misconduct, which states that if a party to the arbitration agreement is a state or an enterprise controlled by the state, it cannot invoke its own law in order to ban a dispute from being arbitrated upon. Okay. In the municipal procedure code in Romania, we have presumption of arbitration for jurisdiction public law, and a rule that the state controlled entities can be parties to arbitration if there is not a contrary provision of the law does not exist. And we have to bear in mind that notwithstanding these permissive rules, sometimes issues of objective arbitrability may arise, depending on the nature of goods. Okay. So very quickly, there are 4 stages when arbitrability is determined. And yeah, I'm sorry. Okay. So, thank you. I don't know, it's taken too long. I'm sorry, the subject is very fast.
So thank you very much. I didn't notice if you said